families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to another episode of Families Divided TV. In tonight's episode, Gene Colman will be speaking to us about family violence and what the reported cases tell us in court. Now, Gene is a Canadian attorney, but what he is giving to us also can be used and illustrated in all countries. So pay close attention. There's much to learn here. He's gone very in depth with this. We're going to have Dr. Gene Colman with us right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Good evening, everybody. I'm Gene C. Colman, family law lawyer in Toronto, Ontario, Canada. The topic of my presentation is Family Violence Update, how are Canada's courts addressing this issue? I would like to give special thanks and recognition to my student, Jordan Shanlin, from the Lincoln Alexander School of Law. So let's move on to our agenda. There it is on the screen. We're going to look at jurisdiction. We're going to get a grounding in the statutory amendments to the legislation that address family violence. We're going to then, importantly, look at the emerging themes in the case law. And hopefully at the end, I'll remember to thank you all. By way of introduction, in all of the cases referenced, the courts found family violence to be a determining factor when making the decision. So we see that themes have emerged since the amendments came into effect, and we will focus on 5 of them. But keep in mind, my friends, these observations that I have are just that. They are not necessarily definitive truths, but simply recognizable patterns that we see from the first year and a half or so, a little more, of this legislation. And it will alert us to what we have to watch for in the future. The 5 items or themes we'll be looking at here are shared parenting time is not guaranteed where family violence comes into play. Accountability in parenting time, one has to take responsibility for the family violence that one engages in. Violence seems to always be a consideration where it is reported in the cases. You behave in a manner that shows impropriety, less than perfect, it's going to have an effect on your parenting time. And I did find in my research gender discrepancies, and we'll discuss that. But first, let's look at the statutes and jurisdiction. The federal statute that is relevant here is the Divorce Act. The Divorce Act addresses married people who are, surprise, divorcing. Provincial legislation, such as Ontario's Children's Law Reform Act, address cases where the children's parents were never married to each other. To ensure that the same changes in the Divorce Act apply to all children, the Ontario government enacted Bill 207 to amend the Children's Law Reform Act in similar terms, if not the same terms, as the federal amendments. We will generally, in this presentation, only refer to the Divorce Act, but please keep in mind that unmarried parents in Ontario and in other jurisdictions with similar amendments will be governed by this new systems. Slides number 6, 7, and 8 give you a rundown on the provinces. Just putting these up on the screen now to bring to your attention that Quebec is a whole different ballgame. And Newfoundland and Labrador, they don't really define family violence so well. They do not track this last time I looked, a month or two ago, they do not track the federal amendments. The territories, also different. Yukon, Northwest Territories, none of it. They are not dealing with family violence, as does the Divorce Act, as does Ontario's Children's Law Reform Act. And so they have a different approach. So if you are listening from one of those areas that I've just mentioned, Divorce Act, if that applies to your case, yes. Otherwise, you have to look, well, you should consult a lawyer in your own jurisdiction. Leave it at that. So let's look at the key family violence sections in the amended Divorce Act. We no longer use words such as custody and access. Surprisingly, the term family violence was not actually defined in the Divorce Act until Bill C-78 came into force on March 1st, 2021. With this amendment, Canada's Parliament has implemented significant, and I would say startling, changes to the law of parenting, formerly known as custody and access. One of these changes, quoting Bill C-78, was introduced, quote, measures to assist the courts in addressing family violence. Family violence, what is it? Well, one would not be blamed if one assumed that we are dealing here simply with assaults, threats to hurt someone, and similar nasty behaviors. Whoa. But the Divorce Act now goes a lot further. Family violence is now a grammatically expanded concept that encompasses behaviors that might surprise you. It's defined, family violence is defined in Section 2 of the Divorce Act. It's should be up on the screen now, slide number 11. As it's conduct, but it doesn't, bad conduct, though the act doesn't say bad, it's on the screen, that whether or not it constitutes a criminal offense. And notice it can be directed by one family member to any family member. It can be violent in itself. It can be threatening. And it can be a pattern of coercive or controlling behavior. These are all new words in the statute, but they've taken from the family violence literature to come up with this. And it causes that other family member or any family member to fear for their safety or for anyone else's safety. So you can appreciate that this is casting a very wide net. Now to slide number 12. So the definition section goes on to give us some examples. This is a fairly long list, A through J, but it's not expressed to be an exhaustive list. So if the behavior comes under A to J on your screen, you're included, but there could be other things that you and I don't contemplate that could be included. Men in particular can be victims of family violence without even realizing that the bad behaviors to which they are subject are caught within the definitional framework. On the flip side of that proposition, men might engage in behaviors that they might think, well, not so bad, but stop right there. The law defines family violence in exceptionally wide terms. It's best to know in advance what the law says. So, what are the takeaways here? And if I repeat myself, you'll bear with me, please. Well, the violence, as I said, doesn't have to equate to a criminal offense. So those say, oh, well, I never got convicted. Doesn't cut it. Any behavior the family member might perceive to be violent or threatening could constitute family violence. Coercive controlling behavior, sexual abuse, stalking. And I say stalking here, the act doesn't say it, but my take on it is that stalking can include online stalking. Now, here's an interesting proposition I'm going to throw out for you. Think twice before canceling credit cards or otherwise limiting spending. It could very well be family violence. Now, I wouldn't have thought that before, but taking this section as a whole, looking at the reading of the section, which I've had for you previously on the screen, canceling credit cards. Now, when I started practicing family law as a lawyer, because I started earlier as a law student, but as a lawyer in 1979, I was taught one of the first things you do, cancel the credit cards. Don't let her bleed you dry. Family violence. Let's say you smash a door or you break a glass even where the other spouse is nowhere near. It's family violence. It's likely family violence, I would say it is. Say you threaten to do any of these bad behaviors, but don't actually do them, family violence. Bad behavior, my friends, in the widest sense of the term, can now constitute family violence. While we're looking at the Divorce Act, we have to focus on one concept: best interests of the child. So in addition to including and defining family violence, the bill further elucidated the concept of, we've all heard it, the best interests of the child. Best interests of the child is statutorily the only test. Section 16 sub 1 of the Act says that, quote, the court shall take into consideration only the best interests of the child of the marriage in making a parenting order or a contact order, end quote. The obligation on the court is not new. It's not new here, focusing on BOIC, but it is still noteworthy that BOIC, best interests of the child, trumps all else. We cannot leave this topic of family violence without turning to another subsection, which is 16 sub 3. That tells us to consider all factors related to the circumstances of the child, including and then it goes on to provide a non-exhaustive shopping list of factors. What is germane for our discussion today, because we're talking about family violence after all, is sections 16.3J and 16.3K, which are up on the screen now. Notice the current focus on the child here. Sub 3, determining the best interest of the child, the court shall consider all factors related to the circumstances of the child, including J, any family violence. That's any family violence against anybody in the household or elsewhere even, and its impact, among other things. Where? Its impact on the ability and willingness of any person who engaged in the family violence to care for and meet the needs of the child. And sub 2, the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate on issues affecting the child. Remember I said that shared parenting wasn't a given? Well, this is one of the reasons, because of family violence, another person, i.e. the other spouse, cannot cooperate with you because they fear for their safety, then shared parenting, whether it's decision-making or time, is not necessarily a given. Sub K, watch sub K here. Watch the reading of that. Any civil or criminal proceeding, order, condition, or measure that is relevant to the safety, security, and well-being of the child. Does it say any criminal conviction that is da-da-da-da? No, it doesn't say that. So you have an interim judicial release provision. It's relevant. You have a diversion program. Let's say you're charged and they agree to put you into diversion and you do whatever the requirements are in that diversion program so you don't get a conviction. You can't say in family court, well, I didn't get convicted. Right here, sub K, it's here. So what are the takeaways from these parts of the Divorce Act if I haven't hammered it home sufficiently already? 16 sub 3 gives us a non-exhaustive list of factors that the court must consider to determine the best interests of the child. There is room here to expand on any kind of bad behavior in my view. The Divorce Act brings back bad behavior into the statutory criteria. Let that one sink in. The Divorce Act brings back bad behavior into the statutory criteria. When the Divorce Act was amended, 1986 was one set of amendments that stands out. When provincial legislation was amended, 1978, 1986. Earlier than that even. Yes, I'm showing my age, aren't I? We were taught, us young family law lawyers, we were taught, don't engage in besmirching the other side, talking about their bad behavior, unless it is relevant to any of the issues. And until these amendments, that was the law, sometimes honored more in the breach than otherwise, because there are situations, even before the Divorce Act was amended, where family violence would be relevant for sure. But I always believe that you don't put in extra things, extra elements of the violence into pleadings, because where there are children, these parents are going to have to parent these children going forward. And we as lawyers are not judges. We don't know what's true and what isn't true. We don't want to poison, we should not want to poison the atmosphere. The Divorce Act brings back bad behavior into the statutory criteria. Now I think a lawyer is obliged to plead the bad behavior. Wow, let that one sink in. Family violence does not have to be committed directly in front of the child. Rather, if the behavior is deemed to constitute family violence, then the court is empowered to consider what the effect of the family violence could be on the child. Nowhere does it say that the effect must be direct. Let us say that you commit family violence against your wife. I'm not saying you shouldn't. Let's just say you do. Know that this can impact the child too. Family violence makes it impossible, or just family violence may, make it impossible or just difficult for your spouse to cooperate with you on parenting issues, as I alluded to a few minutes ago. If the other parent is living in fear of you because of your family violence, widely defined, then perhaps equal shared parenting, formerly called joint custody, will just not be an option. And the next point, there seems to be an implication here that the family violence perpetrator is not at all qualified to really care for and meet the child's needs. And that takes us to an examination of section 16 sub 3 sub J. That's the one about ability and willingness of the family violence perpetrator to care for the child, and it's about the ability of the family violence victim to have to cooperate with the perpetrator. Section 16.3J has further factors set out to assist in interpretation. They're found in 16 sub 4, which brings us to slide number 19. It gives us some factors here. Notice here, sub J of 16.3 sets the stage for a finding that any family violence of any kind has the potential to ensnare you in the court finding that contact with your child is not in his or her best interest, simply because the family violence victim is made to feel insecure, unsafe, etc. 16 sub 4 gives us the roadmap to interpret sub J. So we asked, was there a pattern of coercive and controlling behavior? Did your behavior constitute a risk of harm to the child? Did your behavior cause even any other family member to fear for their own safety? That casts the net very wide indeed. Watch out there for sub H, any other relevant factor. That can capture anything at all. And now let us turn to what I believe to be the most important and earth-shattering factor that should guide all lawyers and litigants in our family law system where family violence is alleged, and it seems as if it will likely be proven. Sub G states, and I quote, any steps taken by the person engaging in the family violence to prevent further family violence from occurring and improve their ability to care for and meet the needs of the child. It's a dramatic pause. This is, in my view, folks, a safety valve. If you are going to be caught by the family violence spider's web, and if you've committed family violence, you should be caught by them. If you have indeed behaved badly within the meaning of the Divorce Act, then you must take substantial, persuasive, credible, and all-encompassing steps to address the issues of your alleged family violence. Your residential time with your child is at stake. Now, let me rephrase that. Your child's time with you, from the child's perspective, is at stake. Your decision-making responsibilities for your child are at stake. In my view, if you can clearly demonstrate that you have changed your ways, that you have gathered education and insight, that you no longer pose any risk of family violence to anyone, then perhaps you will be able to salvage a meaningful relationship with your child. On the flip side now, if you are a victim of family violence and the offending spouse has not taken any steps to ameliorate her behaviors along the lines that I've outlined, then point to this subsection and argue that the court might ascribe some meaning, that the court, must subscribe or ascribe some meaning to it. And in the absence of evidence under sub G, the child is at risk. There are less well-known sections of the amended Divorce Act that mandate an examination of family violence, even when there's been no criminal convictions. Let's turn to those now. Divorce Act Section 7.8. The Divorce Act now recognizes that there could be other orders or similar directives that could be relevant to the divorce proceeding. Section 7.8 of the Act addresses this reality. It charges the court with a duty to, when appropriate, determine if there are any civil protection orders, child protection orders, or any order undertaking a recognizance within the criminal law system. Note, folks, if you haven't heard me say it yet, not just conviction. There are a myriad of other measures that could be caught within Section 7.8. Take note. I'll read my notes again. I really want to get this point home. Take note that an actual criminal conviction or a formal finding under the child protection legislation is not required here. Note I've added in the child protection legislation. If there is any sort of order or direction, then the court can consider it. Is a criminal conviction without proof of guilt good enough? I hate to say it, but it sure is. The Divorce Act requires a parent now who intends to move or relocate, who has parenting time or decision-making responsibility for a child, to give notice of their intention to the ex-spouse and to whomever. Well, if you're in the process of divorce, it won't be quite an ex yet officially, but the Divorce Act applies. Same provisions in Ontario's Criminal Law Reform Act and the other provincial jurisdictions, as I pointed out. You have to give notice. You're moving your residence, you are proposing to relocate to another city even, you have to give notice. But why am I, hey Colman, why are you discussing that? Because if there's family violence of such a kind that the court feels you have to move without giving notice, and your location has to be kept a secret, then you can wave the family violence flag and you can be granted permission. Now, obviously, this would be, in all likelihood, on an ex parte motion or a motion without notice. So while the general law is any relocation, any change of residence requires those notice provisions to be triggered. Where there is family violence, you may not have to give notice. If you were a self-rep, I would suggest to you, before you go without notice, at least get some unbundled services or go to a legal aid clinic or go to a walk-in clinic. Get advice on this before you invoke these provisions. So in the research that Jordan Shanlin and I did, we found 5 emerging patterns. Those themes are: shared parenting time is not guaranteed. There's got to be accountability associated with one's parenting time. You have to take responsibility for your family violence. Violence is always a consideration. We looked at the impropriety in parenting time, that comes out. And there are gender discrepancies. So let's circle back here to the first theme. Shared parenting is not guaranteed. There's this Supreme Court of Canada case. I cannot pronounce it. B versus G, we'll call it. In this landmark case, the mother sought to relocate the children due to emotional abuse by the father, though the father claimed he was good to the children themselves. The father appealed the trial decision, allowing the mother to relocate the children due to wanting to admit more evidence, but the Supreme Court of Canada found that the trial decision will be upheld. Big takeaway here: the maximum contact principle is potentially problematic. Shared parenting is not guaranteed if the offending parent himself or herself is problematic and abusive. It is worth repeating that what is known as the maximum contact principle is only significant to the extent that it is in the child's best interest. It must not be used to detract from this inquiry. And as an aside, the maximum contact principle, in my view, no longer pertains absolutely in any event outside of family violence to the Divorce Act. Now, my dear friend Brian Ludmer, who has presented on this platform, I believe, a number of times, he disagrees. And I, for one, very much respect Brian's views on this. We've had some discussions about the matter, but looking at the legislation overall, Well, I would like the maximum contact principle to still apply. I don't believe it does, but that's for another day. Back to family violence. Droit de la famille. 2023 Quebec Superior Court case. Despite being a present father, he frequently subjected the mother to emotional, financial, and physical violence. While the court found that the father was not violent with the child, they still allowed for the mother to relocate where? Back to Mexico with the child, only allowing the father a few scheduled weeks of parenting time throughout the year. The acts of violence by the father, well, he choked the mother on multiple occasions, once in front of the child. There were incidents of road rage, and the child was present. He got into a fight with a neighbor at a neighborhood barbecue or something. He broke the nose of another guy. Child witnessed this. And I quote from the case, shared parenting time is not a right that a parent has over his or her child, but rather is a form of arrangement of parenting time which could be put in place when it is in the best interest of the child to do so. The choice of one arrangement over another is not intended to reward or punish either parent. So if you're violent, especially if the child witnesses it, especially if it's going to turn out, in all likelihood, very, very bad for you. And it's turning out bad for you because you don't have contact with your child. You don't have decision making for your child. It's turning out even worse for your child because children need both parents, but children must be safe. Bidgood versus Marston, a very recent case. The mother had fled the family home with the children to the UK before the legislation came into effect. And there was a criminal no contact order issued against the father. The father, for years, had been beating the mother and children, threatening them, neglecting them. The mother's final straw was when the father threatened to buy a gun and kill the family. Those sorts of cases under our legislation, even before our legislation, amended legislation, in fact, that you could get an order on motion without notice in the province of Ontario. The father asked the court to have the children returned to Canada and order reunification therapy. There was continuous litigation regarding the issue, although the divisional court determined that the children should remain in the UK as the motion judge failed to consider family violence when ordering their return to Canada. So in other words, no, the final result was by the divisional court, which is a section of the Superior Court, 3 judges of the Superior Court sitting in appeal. So the court heavily weighed the voice of the mother, the children who were adamant they didn't want to see their dad ever again, and the divisional court decision. So even the youngest child, who was a baby at the time, didn't understand any of this. It was ordered not to have any connection at all with the father due to the family's concerns. Bad violence, bad result. Had I been counsel for the father in that case, I would have gone to every single sort of program and therapy and helped him to become the best he could possibly be. That's how I would have handled that. Not say, well, it's not so bad or whatever excuse the father had here. In conclusion, I find it is not in the best interest of the children to return to Canada and reside with the father as requested, or for the children to have any virtual or in-person contact with the father on an interim basis. While I appreciate that VM was a baby at the time of the mother's separation and not part of the OCL process, there is some evidence that he was present during the incidents of violence in 2020. More importantly, the older children's concerns about their father and reluctance to return to Canada relate not only to their own fear of harm, but of possible harm to their mother and little brother. Remember, I pointed out earlier that it's anyone in the family that has a fear. I find that to allow virtual parenting time with VM, who is now 3 years of age, will potentially be confusing for OM and LM, I guess with the siblings. and would compromise their sense of safety of their family unit. The father's application for interim parenting order on the terms and conditions he requested is dismissed. Theme number 2, accountability and parenting time. Courts are more likely to grant parenting time to parents who have clearly demonstrated their willingness to co-parent respectfully and take accountability for their waywardness. A case in point is Whitaker, recent case from the Ontario Superior Court of Justice. The father's enrollment in treatment programs for his alcohol addiction and relationship problems were a, quote, step in the right direction, unquote. Parenting time was reinstated, albeit it was supervised. In this case, the father was a physical therapist and he did have some alcohol problems. He had parenting time up until the time there was a domestic violence incident with his current wife in which he was ordered not to attend at her home. He breached this order. That's not good. He breached the order and faced criminal charges, therefore launching a, surprise, surprise, Child Protection Agency investigation. Moving forward, his parenting time was to be supervised. The father, in this case, however, took accountability and sought help for his issues. He took all the right steps directed by the court, therapy, getting sober, etc., etc. So what does the judge write at paragraph 31? And I quote, I accept that the respondent has acknowledged his alcohol problems and that he is now regularly attending AA meetings. He has enrolled in programs that are focused on assisting him with addiction and relationship issues. This, in my view, is a step in the right direction. Furthermore, the respondent is now subject to charges in the criminal courts, and therefore he will be subject to recognizance in the criminal proceedings, end quote. Had that father not taken accountability for his actions, had not sought out treatment, in my view, he would not have gotten anything. Next case, CS versus KM, also recently in the Ontario Superior Court of Justice. The trial issue regarded parenting time. The mother believed that the father's time should be supervised, while the father believed it should be unsupervised every other weekend. The father had had a troubled history marked by criminality and conflict, where the mother was found to be protective of the children and a credible witness. The court found that the children and father loved each other and that the children liked spending time with him when he is able to control his behavior. But, 1, the father does not follow court orders. 2, he did not comply with trial directions set out by the trial judge. 3, his litigation behavior confirmed the mother's evidence that he's difficult to deal with and irresponsible. And 4, he threatened the mother. The mother was deemed a credible witness, and she even spoke of the father's strengths, which of course made her more credible. She provided multiple text messages from the father and children, demonstrating the children being fearful of him. And before I quote from the case about text messages, I am amazed when I asked to review people's text messages for the period of time before they came to our office, and I see what people write to their spouse and to other family members. You don't think that's going to become evidence? Watch what you write. Watch what you say. Be circumspect. Be careful. Now, the quote from the case. Mommy, Daddy is scaring me. He was talking to Grandma and saying not to give the baby to S because she stole his F.ing wallet, but she didn't. And he was going to hit her or something. We were watching S go home now, and she was crying. My heart is racing. He was swearing so much and yelling at Grandma in her room. So, like I said, you direct your violence, you direct your anger, you direct your frustration at your mother-in-law, at your father-in-law, at a dog even. It's not going to turn out well for you. He writes, the fellow writes, don't get my children involved in your woman BS, but in full. I already told you that if I was an abuser and punched you in the face, you still would have had to send my children to me. Okay, so bring it up in court. End quote. Oh my goodness. So the father, despite warnings from the court, was unable to alter his conduct and violent behavior, and the court established that he would need to demonstrate, quote, sustained changes in his conduct for at least a year before being able to request a change to the parenting time order. The overall theme here demonstrates it is not perfection that's required, not complete sobriety, etc., but genuine change and a willingness to alter patterns. You don't want to change. You're not having any treatment. We know what the result's going to be. Next case, KB and AT, also 2023. This one's from the Nova Scotia Supreme Court. The father physically abused the mother on 2 separate occasions, once while she was pregnant and once at the time of separation. He physically assaulted her, causing her to obtain body x-rays and cut her lip open. Emotional abuse and coercion were also found to be consistent throughout the entire relationship. Supervised parenting was ordered during the proceeding. The mother sought sole decision-making without consultation and supervised parenting time between the father and the child. The father sought unsupervised parenting time every second weekend, additional parenting time during holidays and special occasions, and, of course, joint decision-making. The court determined that despite him being a loving father and his ability to interact positively with the child, it was in the best interest of the child for the father's parenting time to remain supervised due to what? His lack of accountability. Supervised parenting time, the judge wrote, will continue until the father gains insights and has successfully completed a therapeutic program with the following stated objectives. Just to move things a little bit, I'll just leave those up on the screen for a moment. You can read them. Just understand the theme here is take accountability, take responsibility, and where you got a problem, get treatment. Hunt versus Hunt, also a recent case out of the SCJ, Ontario Superior Court of Justice. The parents separated, but the mother promised the father nearly shared parenting. The father accepted a new job out of their hometown and shortly after was charged with 12 counts of assault, all historic allegations by the mom. During the criminal proceedings, parenting time for father was to be supervised at an access center or an approved party by the mother. So the mother files an application, surprise, surprise, for sole decision-making, primary residence, and supervised contact for the father along with support orders. The father then brought a motion for unsupervised parenting time, but the court denied his request until more evidence could be gathered, like an OCL report. The father was found guilty on only one of the 12 accounts, namely squeezing the mother's arm and leaving a mark, but he appealed. Now here, due to the conviction being appealed, it was not relied upon when assessing the safety of the children. This case might be an outlier, not so sure. We'll have to see. The case does show how accountability really does count. In this case, the father's enrollment in the father did enroll in parenting and mental health programs, and the OCL report demonstrated the father's willingness to change. And so the judge considered all this. The judge found that the father's positive steps allowing for his parenting time to be increased and made unsupervised parenting time, despite the mother's allegations. Back to the Bigwood and Marston case. This case shows that the father made efforts. His evidence of that just didn't cut it, though. You have to have decent evidence, which means you have to have made some real efforts to reform your behavior and attitudes. Quoting from the case, in assessing the impact of the family violence, the court is required to consider any steps taken by the person engaging in the family violence to prevent further family violence from occurring and to improve their ability to care for and meet the needs of the child, right? Just like I told you. Here, there is evidence that the father was struggling with his mental health in at least the fall of 2020 prior to mom's departure. While the father appears to have taken some steps to see some professionals, the good judge writes, the evidence presented does not provide much assurance that he is adequately addressing his mental health issues so as to ensure the safety of the children when they're in his care, when they're placed in his care. So what this shows us is it's not okay just to go get any random therapist or to enter into any random program. You really have to make sure that your evidence is really convincing. And you really do have to change. You have to recognize that family violence is a problem. We live in a violent society, unfortunately. And this affects us, media, you name it. And if we've misbehaved, we've got to remedy it. And the Act allows for it, as I pointed out. So violence is always to be a consideration, even if it is not directed towards a child. And we're back to that Supreme Court of Canada case with the unpronounceable name. Quote, the suggestion that domestic abuse or family violence has no impact on the children, has nothing to do with the perpetrator's parenting ability, is what? Untenable. Research indicates that children who are exposed to family violence are at risk of emotional behavioral problems throughout their lives. CS versus KM, the case reminds us that children witnessing abuse is family violence. Court, of course, relies on the B versus G case. The father went, in this case, in CS versus KM, from being a fully involved parent to supervised visits only. Next one, KB versus AT. I think we mentioned that already. Sounds like a great dad. The result is still supervised parenting. The father and the child, quoting from the case, the father and the child have much love for each other. Child is happy in the father's care. Child's best interest to have regular, consistent parenting time with dad. Father, many positive experiences to share with his son. Family, community, outdoors, nature, fishing. Boy, great list. In addition, the child's biracial, so race was a factor here. We have to look at that. He needs to embrace both sides of his culture, his family. But despite all that, the father still ends up just with supervised time, because you can't ignore family violence that had occurred. And I would say even more, equal importance, maybe more important than on the facts of the case, you have to take responsibility. You have to take responsibility. Theme number 4 now, impropriety in parenting time. We'll deal with that on slides 40 to 43. Poor and coercive behavior, particularly in active litigation. Courts will reprimand you, and they may greatly hinder your parenting time and decision-making responsibilities. Wilson and Wilson, recent case. From Ontario, the father was abusive towards the mother, and despite being a decent parent to the children often witnessed the father's poor behavior. The father constantly undermined the mother to the children. He yelled in front of them and refused to disclose his new address despite taking the children to his new home. So the judge states, Mr. Wilson must understand, however, that his parenting time is not unfettered, and that any further problematic conduct on his part will have dramatic consequences to his access to his sons. And that in particular, if there is any further abusive behavior on his part, he risks losing his parenting time altogether. S versus MBT, recent case from the Ontario Court of Justice. It was a case about parenting arrangements for a 12-year-old. The father was a Kenyan refugee claimant in Canada. He agreed the child should primarily reside with mom. He wanted alternate weekends, not on its face an unreasonable request, of course. The mother had been the primary caregiver, and after separation, the child had only 2 virtual visits with the father, not much. It was determined that it was not in the best interest of the child to have parenting time with her father. Family violence was a large factor, a determining factor, as the father was extremely emotionally abusive. Every bad behavior in the book this fellow engaged in. Looking at how bad he was, and the bad things he said and he wrote to the wife, and the threats, and I don't know, even in this case, if he entered into a major program of therapy and treatment, if he would have achieved time. But certainly going into court with this sort of evidence, I do hope this, I don't recall offhand, but I do hope he was self-represented and didn't have a lawyer pushing this forward and wasting his money. Let's talk about something a little more pleasant, using that term advisedly. Gender discrepancies. The emerging cases, particularly those in which parental alienation is a prevalent factor. I guess Elaine Comte is very glad that I said the words parental alienation, because of course the wonderful, let's not leave this program without praising Elaine and the fantastic work she's done over the last number of years in raising awareness of parental alienation and bringing all these fantastic programs and top-notch people, I don't include myself there, top-notch people to the platform to share their research and their guidance and their modes of therapy, etc., with the public. And hats off to Elaine. So I mentioned parental alienation, so let's get back. Emerging cases, particularly those in which parental alienation is a prevalent factor, have demonstrated that courts are slightly more willing to dismiss the violent behavior exhibited by women, albeit rarely without criticism, than they are with men demonstrating similar behaviors. We have 3 examples to illustrate this point. The first one is the case called DGT versus VJI from British Columbia, a recent case. The mother falsely accused the father of molesting their child. Professionals in observation of the family stated that parental alienation was a problem in the family and that the mother was alienating the child from the father. The court also found the mother to be in breach of a multitude of court orders. And I say that constitutes family violence. Her behavior constitutes family violence. Yet, the court found that shared parenting was in the best interest of the child. The court did issue a police enforcement of the parenting order given the mother's history and past conduct. But folks, let's switch the genders and you tell me what you think the result would have been. I know what it would have been. Next one, we got the case of MAB versus MGC, a little older case, 2022 in the Ontario Superior Court. The mother accused the father of neglecting and abusing the child, family violence. Rather, it was found that the mother was actually the one committing parental alienation by gating the child from the father, subsequently causing emotional distress to the child. And I say that's family violence. The decision is amazing. Amazing. You have to take the time to read it, folks. And would not likely have been the same, in my view, had the genders been reversed. Despite the mother's poor behavior, she was still given primary parenting time and decision-making, but with significant safeguards in place, including not being able to speak negatively about the father or distribute photos of abuse by the father to third parties. She was also ordered to consult the father about important issues pertaining to the child and only communicate with him in a positive manner through our family wizard. Well, I certainly agree with using our family wizard. I prefer the Canadian comparable program called Come to Agreement. So keep that one in mind, please. Let's keep the business in Canada. But how does a mother who engages in alienating behaviors, marginalizing the father, come out with being the primary parent? What if the genders had been reversed? Next case, Gravel versus Dufresne. Also, recent decision of the Ontario Superior Court of Justice. Initially, the mother was granted majority parenting time with the children and sought to further reduce the father's parenting time despite him actively seeking to increase it. The mother admitted to making false allegations about the father's abuse. She admitted to it and admitted to throwing hot coffee on him, amongst other elements of family violence. She withheld the children for a full month from the father. I can hardly wait for a court to rule that withholding children for no reason is actually family violence as well, but that's probably stretching it, but I would welcome such a ruling. The mother had long been struggling with bipolar disorder, but refused to take her meds and address her symptoms. Failing to get her mental health in check is said to have resulted in many of the accusations against the father, the husband, and her poor behavior. So she fails to get treatment, fails to take her meds, and that's an excuse. Despite the mother's actions, shared parenting was still granted, but the father was granted majority decision-making responsibility except for schooling. So I asked the question, you guys know what I'm going to ask. What if the genders had been reversed? So let's sum up, my friends. Let's sum up. What have we learned? What have you learned? I hope we've learned something. The majority of provinces have adopted similar provisions as set out in the Divorce Act. The territories, Newfoundland and Labrador, and Quebec have not. Secondly, there are key sections of the Divorce Act and similar provincial statutes that specifically define and address family violence. Family violence must always be considered when determining the best interests of the child and making parenting orders. There are 5 recognizable patterns emerging from the case law since the Divorce Act amendments came into effect in March 2021, I believe it was. 1, shared parenting time is not guaranteed. Committing family violence against one's spouse and or children has serious consequences and will result in the court granting to you only a minority of parenting time or worse. 2, accountability in parenting time. Taking responsibility for the family violence that you've engaged in. If you take responsibility for your family violence, it will likely be better for you. Parents, albeit having committed family violence, are more likely to exercise parenting time, to be allowed to exercise parenting time and have their decision-making responsibility if they're able to take what? Accountability for their actions. 3, family violence is always a consideration. Even if the child is not the targeted victim of the family violence, the court will consider any incidents of family violence in the home. And as we heard, even outside of the home at a community barbecue on the road where there's road rage. Remember talking about that. Number 4, impropriety in parenting time. Parents who continue to act improperly and continue to act violently against their spouses and or children, despite direction to stop, though we don't need the direction, but despite direction to stop, are likely to be penalized by the courts by not getting the orders they ask for, i.e. shared parenting time, unsupervised parenting, decision-making responsibility. And 5, gender discrepancies. While either spouse can instigate family violence, emerging case law demonstrates that acts of family violence that moms commit are more likely to be pardoned, excused, explained away than would be the same acts of family violence that the father committed. Caveat: if you're a mom who has committed family violence, listen to this presentation. Do not rely on what Gene C. Colman just stated and thinking you're going to get away with it. I'm showing some trends, some themes that Ms. Shanlon and I have perceived in the case law. Every case is different. This is a general application to everybody. Every case is different. And the courts do strive to deal with the cases on their individual merits. For questions, by all means, feel free to send me an email, Gene, Gene, at complexfamilylaw.com. It's up on the screen now, the last slide number 51. And do keep in mind, however, that I cannot really comment on particular cases before the courts. I don't have all the facts, but if you have some feedback about this presentation, you have some question arising from this presentation, I'd be happy to take a few moments and respond to your questions, since I'm taping this beforehand. Thank you for participating in this webinar, and have a great rest of the evening. Good evening.
Next week, Dean Tong will be discussing when Child Protective Services knocks on your door.